U Visa 2025. How to get approved fast and avoid deportation. Hello everyone, and welcome back to our channel, where we provide real immigration updates, strategies, and legal insights to help you navigate the complicated U.S. immigration system. Today, we're discussing the U Visa in 2025, what's causing delays, how to expedite your case, and what you should do if you're at risk of deportation. Stay until the end, because I'm going to reveal the most important step that can help you avoid getting stuck in the system for years. Let's get started. What is the U Visa? The U Visa is a special visa for immigrants who have been victims of certain crimes, suffered mental or physical abuse, and are helping law enforcement in investigations or prosecutions. This visa provides legal status in the U.S. work authorization, a path to a green card and citizenship. However, the backlog is massive, and many applicants are waiting 7 to 10 years for approval. Now, let's talk about why it's taking so long and what you can do about it. Why is the U Visa taking so long? The U Visa has an annual cap of 10,000 approvals per year, but over 300,000 applications are pending. Applications filed in 2016 or earlier are still being processed, which means new applicants must wait even longer. USCIS prioritizes certain cases, which means some applications move faster than others. How to expedite your U Visa case in 2025? The good news: you can speed up your case, but only if you take action. Here are 3 powerful ways to expedite your U Visa approval. Option 1. Humanitarian expedite request. You can request an expedite from USCIS if you have a serious medical condition, extreme financial hardship, and immediate danger to your safety. How to submit a request. Keycap 1. Write a letter explaining why your case needs to be prioritized. Keycap 2. Attach supporting documents, medical records, police reports, financial statements. Keycap 3. Have a lawyer or community leader support your request. If your request is approved, your case could move up in priority. Option 2. Congressional assistance. Did you know your local congressman or senator can put pressure on USCIS to move your case faster? Here's how it works. Keycap 1. Find a representative. Go to house.gov or senate.gov and look up who represents your district. Keycap 2. Call their office. Explain that you are waiting for a U Visa and need help. Keycap 3. Submit an official case inquiry. They will contact USCIS for an update and possibly push your case forward. This method has helped thousands of people get their U Visa faster. Option 3. Filing a lawsuit against USCIS. If your case has been delayed for more than 5 years,
I talked to the Deputy Attorney General all this weekend. They've opened up a criminal investigation, and they have promised that not only this person lose their job and lose their pension, they're going to go to jail. They're going to criminally prosecute.
¿Por qué? Ayúdame, por favor. ¿Por qué? ¿Por qué? ¿Por qué? No me peleando.
We're all over it. We got the DHS-IG investigating the first one. I have a pretty good idea what happened. Can't share a lot because it's under investigation, but the IG's opened up a criminal investigation on the second one. We're sending a strong message. Given the bag
writ of mandamus lawsuit. What does this do? It forces USCIS to process your application instead of leaving it in limbo. The results: many applicants saw movement on their cases within months of filing a lawsuit. Important: this lawsuit does not guarantee approval, but it forces USCIS to make a decision. What if you left the U.S. while waiting for a U Visa? Many applicants left the U.S. due to emergencies, but now cannot return until their U Visa is approved. If you're outside the U.S., here's what you need to do. File Form I-192. This is a waiver request that asks USCIS to allow you to re-enter the U.S., provide strong evidence, medical reports, financial hardship documents, or proof of urgent family situations. If approved, you may be allowed to re-enter and continue waiting. In the U.S., biggest mistakes that cause you visa delays or denials. Mistake number 1. Not updating USCIS with new contact information. If you move, change your phone number, or update your email, you must inform USCIS immediately. Failure to update your details means you might miss important notices leading to delays, or even DEN, U Visa 2025. How to get approved fast and avoid deportation. If you're waiting for your U Visa and feel stuck, you're not alone. The process is slow, but there are ways to speed up. In this video, I'll guide you step by step on how to take action right now. Stay until the end because I'll reveal the most important thing that can make or break your case. Step 1. Understanding U Visa delays. The U Visa backlog is massive. If you applied years ago and still haven't heard back, it's because USCIS has over 100,000 pending applications. Normally, processing takes between 7 to 10 years, but some cases can be expedited. Step 2. Can you expedite a U Visa? Yes, but only in certain situations. Here's what you can do. 1. Request a humanitarian expedite. If you have medical emergencies or severe financial hardship, file Form I-192 for a waiver. 2. Contact your Congress representative. They can make an inquiry into your case and push for faster processing. 3. File a lawsuit against USCIS. If your case is beyond normal processing times, a writ of mandamus can force a decision. Step 3. What if you left the U.S.? If you left the country while waiting for your U Visa, you are now inadmissible until it's approved. But there is hope. You can apply for Form I-192. This waiver allows you to re-enter the U.S. if granted. If denied, you must wait outside the country until USCIS approves your visa. Step 4. The most important step to avoid deportation. Here's the biggest mistake people make. They don't take action and assume USCIS will process their case eventually. But the reality is, USCIS often prioritizes active cases. If your case is taking too long, you need to push for updates, submit an expedite request, or contact legal experts. Final thoughts. If you're stuck in the U Visa backlog, don't wait. Take action today. Request an expedite, file for a waiver, or seek legal help. Time is crucial. If this information was helpful, leave a comment with your experience, and I might cover your case in the next video. U Visa 2025. How to get approved fast and avoid deportation. Hello, and welcome to this important discussion on the U Visa process, delays, and what you can do to speed up approval while avoiding deportation. If you are a U Visa applicant or thinking of applying, this is critical information you must know. Stay until the end because I will reveal the most effective strategies to avoid common mistakes, increase your chances of approval, and potentially expedite your case. Let's get started. What is the U Visa? The U Visa is a special immigration benefit designed for victims of crime who have suffered mental or physical abuse and are willing to help
guys a heads up so they can escape apprehension. Right? We're arresting, giving, the Venezuela gang a heads up so we can't arrest them. You're putting officers' lives at risk. It's only a matter of time if we walk into a place where there's going to be a bad guy doesn't care. He's going to be sitting and wait for the officers to show up and ambush them. This is not a game. So DHS and DOJ are connected at the hip to hold these people responsible in the criminal fact.
law enforcement in investigating or prosecuting the crime. This visa provides work authorization and a pathway to permanent residency, making it one of the most valuable forms of relief for immigrants who have faced serious harm. However, the wait times are extremely long, and many applicants have found themselves stuck in limbo, waiting years for a response. This leads to a critical question. Why is the U visa taking so long? The main reason for delays is the huge backlog. The U.S. government only issues 10,000 principal U visas per year, and there are currently hundreds of thousands of applicants in line. If you applied back in 2015, 2016, or 2017, you're still waiting in a long queue with thousands of others. Unfortunately, if your case has not yet been approved, you are probably feeling frustrated, worried, and unsure about your next steps. But don't worry. There are options to speed up the process and protect yourself. Can you expedite your U visa? Yes, but only in certain situations. Let's talk about the 3 main ways to expedite a U visa case. Option 1. Humanitarian expedite request. If you have severe medical issues, financial hardship, or safety concern, you can request USCIS to expedite your case under humanitarian grounds. To do this, you should submit a written letter explaining your urgent situation. Supporting documents, such as medical records, financial statements, or police reports. A letter from a lawyer, doctor, or community leader supporting your request. If USCIS finds your case urgent, they may move it forward. However, this method does not guarantee approval. Option 2. Congressional inquiry. Many people don't realize that your local congressman or senator can help push USCIS to process your case faster. To do this, contact your state representative and explain your situation. They can request a case inquiry on your behalf. Option 3. Filing a lawsuit against USCIS. If your case has been delayed for more than the normal processing time, you may be able to file a writ of mandamus lawsuit against USCIS. This lawsuit forces USCIS to act on your case, making them provide a decision rather than leaving it pending. However, a lawsuit does not guarantee approval. It only forces a response. What if you left the U.S. while waiting for a U visa? Many applicants face a major issue. They applied for a U visa, left the U.S. due to emergencies, and now cannot return. If you left the country while your U visa was pending, you may be inadmissible until your visa is approved. But there is still hope. How to re-enter the U.S. While waiting for a U visa. If you left the U.S., you must file Form I-192, which is the application for advance permission to enter as a non-immigrant. This waiver allows you visa applicants to request permission to return while their case is pending. If approved, you may be able to re-enter the U.S. and continue waiting for your visa from within the country. Common mistakes that cause U visa denials or delays. Let's talk about the biggest mistakes people make that can ruin their U visa case. Key cap 1. Not updating USCIS with new contact information. If you move to a new address or change phone numbers, USCIS must be updated immediately. Failure to do this means you might miss important notices, and your case could be delayed or even denied. Key cap 2. Failing to respond to requests for evidence RFE. If USCIS asks for more documents and you do not reply on time, your case could be automatically denied. Key cap 3. Not following up on your case. Many applicants assume USCIS will work on their case automatically. The truth is, USCIS prioritizes cases that are actively followed up on. If you have been waiting for years, it's time to contact USCIS, request a status update, and push for a response. Final and most important step, take action now. Here's the truth. If you do nothing, your case will continue to be delayed. The applicants who get approved the fastest are the ones who request an expedited review if they qualify. Reach out to Congress to press, file a legal action, writ of mandamus, if they have waited too long. So don't wait. Take action today. Conclusion and next steps. If this video helped you, make sure to like and share to help others stuck in U visa delays. Subscribe for real immigration updates. Comment below with your case details. May cover yours next. Thank you for watching, and I hope you get your U visa approved soon. Sure, USCIS.
Immigration law can be very complicated. Navigating through the myriad of rules, regulations, and paperwork can be overwhelming for anyone, especially for those who are new to the country and unfamiliar with the legal system. Understanding the different types of visas available is crucial for immigrants seeking to live and work in the United States legally. There are many different visas and rules. Each visa serves a specific purpose and has its own set of eligibility criteria, application processes, and benefits. Knowing which visa to apply for can make a significant difference in an immigrant's journey. This essay will talk about 3 important visas: U visa, T visa, and VAWA. These visas are designed to protect and assist immigrants who have faced severe hardships and need legal status to rebuild their lives. These visas help immigrants who have been victims of crime or abuse. They provide a lifeline to those who have suffered and offer a chance for a new beginning in a safe environment. The U visa is for people who were victims of certain crimes in the United States. This visa is specifically for those who have endured significant physical or mental abuse as a result of criminal activity. To get a U visa, you need to help law enforcement with the investigation or prosecution of the crime. This cooperation is essential as it helps authorities bring perpetrators to justice and ensures the safety of the community. The T visa is for victims of human trafficking. Human trafficking is a grave violation of human rights, where individuals are exploited through force, fraud, or coercion. Human trafficking is a serious crime where people are forced to work or engage in commercial sex acts. Victims often endure inhumane conditions and are deprived of their freedom and dignity. VAWA helps immigrants who are victims of domestic violence. The Violence Against Women Act, VAWA, provides protection and support to those who have suffered abuse at the hands of a spouse, partner, or family member. Domestic violence is abuse by a spouse, partner, or family member. It can take many forms, including physical, emotional, and psychological abuse, and it often leaves lasting scars on the victims. These visas are important because they offer protection to vulnerable immigrants. They provide a legal pathway for those who have been wronged to seek justice and rebuild their lives. They allow immigrants to stay in the United States legally. This legal status is crucial for accessing essential services, finding employment, and integrating into the community. These visas also give immigrants a work permit so they can support themselves. Being able to work legally provides financial stability and independence, which are key to starting a new life. In some cases, these visas can even lead to a green card, which allows someone to live and work in the United States permanently. This permanent residency is a significant step towards achieving the American dream. These visas recognize that immigrants who are victims of crime or abuse need help. They acknowledge the unique challenges faced by these individuals and provide the necessary support to overcome them. They give immigrants a chance to rebuild their lives in safety. With the protection and opportunities these visas offer, immigrants can focus on healing and building a brighter future. They offer a path to a better future for immigrants and their families. By providing legal status, work permits, and a potential pathway to permanent residency, these visas empower immigrants to contribute to their communities and achieve their goals. In 2025, ICE, Immigration and Customs Enforcement, has introduced new policies that significantly affect immigrants living in the United States. These policies are designed to address various aspects of immigration enforcement, and they have far-reaching implications for many individuals and families. These policies can be quite confusing, especially for those who are not familiar with the legal jargon and the intricacies of immigration law. Therefore, it's crucial to understand them thoroughly to navigate the system effectively and ensure that you or your loved ones are protected. In this section, we will delve into the specifics of who is safe from deportation under these new policies. Understanding these protections can provide peace of mind and help you take the necessary steps to secure your status. One of the key protections is for individuals who have a pending T visa application. The T visa is specifically for victims of human trafficking who have assisted law enforcement in the investigation or prosecution of human trafficking cases. If you have a pending T visa application, you are safe from deportation. This means that while your T visa application is being processed, ICE cannot deport you. This protection is crucial as it allows victims of human trafficking to remain in the country and continue to assist law enforcement without the fear of being deported. Another group that is protected under these new policies is special immigrant juveniles. These are children who have been abused, neglected, or abandoned by one or both parents and have been declared dependent on a juvenile court. Special immigrant juveniles are granted protection because of their vulnerable status. They are often placed in foster care or with legal guardians, and the protection ensures that they are not deported while their cases are being processed. If you have a pending U visa application, you are generally safe from deportation as well. The U visa is for victims of certain crimes who have suffered substantial mental or physical abuse and are helpful to law enforcement or government officials in the investigation or prosecution of criminal activity. However, there are some exceptions to this protection. If the United States Citizenship and Immigration Services (USCIS) makes a negative bona fide determination, you may not be safe from deportation. This determination means that USCIS does not believe you are a victim of a qualifying crime or that you have not met the necessary criteria for the U visa. A negative bona fide determination can be a significant setback, but it is important to seek legal advice and understand your options if this happens. There may be other forms of relief available. and an experienced immigration lawyer can help you navigate this complex situation. If you have a pending VAWA, Violence Against Women Act petition, you are also safe from deportation until USCIS makes a decision on your case. The VAWA petition is for victims of domestic violence, and it allows them to seek protection and legal status independently of their abuser. This protection is vital as it empowers victims of domestic violence to come forward and seek help without the fear of deportation. It provides them with the time and security needed to build a new life free from abuse. While your VAWA petition is being reviewed, ICE cannot deport you. This gives you the opportunity to gather the necessary evidence and present your case effectively. Understanding these protections and knowing your rights can make a significant difference in your immigration journey. It is always advisable to seek legal assistance to navigate these complex processes and ensure that you are taking the right steps to secure your status and protect yourself and your family. While many immigrants are safe from deportation under the new ICE policies, it's important to understand that not everyone is completely out of danger. The policies have provided a sense of relief to many, but there are still specific groups of individuals who remain vulnerable to deportation. Some immigrants are still at risk, and it's crucial to identify if you fall into one of these categories. Knowing your status and understanding the risks involved can help you take the necessary steps to protect yourself and your loved ones. It's crucial to know if you fall into this category so you can take appropriate steps to protect yourself. Consulting with a knowledgeable immigration attorney can provide you with the guidance you need to navigate these complex situations. One group at risk is U visa applicants whose petitions have been denied. The U visa is designed for victims of certain crimes who have suffered mental or physical abuse and are willing to assist law enforcement in the investigation or prosecution of the criminal activity. However, if your petition is denied, you lose the protection from deportation that the U visa provides. If USCIS denies your U visa petition, you will no longer be protected from deportation. This can be a devastating blow, especially for those who have already endured significant trauma. It's essential to understand the reasons for the denial and to seek legal advice on how to proceed. This is why it is important to have a strong case and to work with an experienced immigration attorney. An attorney can help you gather the necessary evidence, prepare your application, and represent you throughout the process. Another group at risk is T visa applicants who have received a final negative decision. The T visa is for victims of human trafficking who are willing to assist in the investigation or prosecution of trafficking cases. A final negative decision means that your application has been denied and you have exhausted all appeals. In this situation, it's crucial to contact an immigration attorney immediately to explore other legal options. There may be other forms of relief available to you, and an attorney can help you understand your rights and options. Finally, VAWA applicants who fail the prima facie test are also at risk. The Violence Against Women Act, VAWA, allows certain spouses, children, and parents of U.S. citizens and lawful permanent residents to file for immigration relief without the abuser's knowledge. The prima facie test determines whether you have presented enough evidence to establish that you are a victim of domestic violence. If you fail this test, your VAWA petition will be denied, and you could face deportation. This can be a frightening and overwhelming experience, but it's important to remember that you are not alone. There are resources and support available to help you through this difficult time. In conclusion, while many immigrants are safe from deportation under the new ICE policies, there are still specific groups who remain at risk. U visa applicants with denied petitions, T visa applicants with final negative decisions, and VAWA applicants who failed the prima facie test are all vulnerable to deportation. It's crucial to understand your status and to seek legal advice if you find yourself in one of these categories. An experienced immigration attorney can provide you with the guidance and support you need to navigate these complex situations and to explore other legal options that may be available to you. Remember, knowledge is power. By understanding the risks and taking proactive steps, you can protect yourself and your loved ones from the threat of deportation. Stay informed, seek legal advice, and take action to safeguard your future. The journey may be challenging, but with the right support and resources, you can navigate these difficult times and work towards a more secure and stable future. The immigration system can be complex and daunting, but you don't have to face it alone. Reach out to trusted legal professionals and support organizations to help you through the process. Together, we can work towards a fairer and more just system that protects the rights and dignity of all individuals regardless of their immigration status. If you or someone you know is at risk, don't wait. Take action today to protect your future and ensure your safety. The path may be difficult, but with determination and the right support, you can overcome these challenges and build a better future for yourself and your family. Stay strong, stay informed, and seek the help you need to navigate the complexities of the immigration system. Your future is worth fighting for. Section 4. What happens when USCIS denies a petition? Having your USCIS petition denied can be a scary and confusing experience. It's essential to understand the potential consequences and know what steps you can take to protect your rights. When USCIS denies your petition, you will receive a Notice to Appear, or NTA. This document informs you that you must appear before an immigration judge, who will decide whether you should be deported.